So I'm attorney Harry Steven Ellman. I'm a solo practitioner practicing for a long time, since 1971. There was a hiatus there where I was out of the practice law and in the title insurance business. I had my own title insurance agency for 20 years called Fidelity Title Company out of Bingham Farms, Michigan. I still do title work. I'm affiliated with a company called Title Connect in Farmington Hills, and I push clients that I've had for over 20 years to them for their title work. But predominantly, I'm practicing law majority of the time. I'm here today to speak about the Seller's Disclosure Act of 1993 because I understand the audience consists of a lot of wholesale purchasers and flippers, and they need to be apprised of all of the ins and outs of the Seller's Disclosure Act. So I have handouts with bullet points about the Act, and then we're going to do a little pass out of a case that I actually was involved in, and attached to it is the Seller's Disclosure Statement is filled out by the flipper, and the 12-page opinion of the court. So we're going to have the audience try to guess, based on the Seller's Disclosure Statement and my complaint, whether I won or lost. So that's going to be the mystery of the evening.
Speakers, so let's give them a really warm welcome.
Thank you. So I'll blow my own horn, do my own introduction. I'm a solo practitioner, been practicing since before a lot of you were born, 1971 I was sworn in, and practiced law for 20 years, and then I had an opportunity, became friends with the founder of now known as Flagstar Bank, who gave me an opportunity to open my own title insurance agency. So in 1987, in Bingham Farms and Telegraph Road, I ran Fidelity Title Company for 20 years and didn't practice the liquor law. And then in 06, and things started happening with the economy and underwriters were getting rid of agents, I found myself back in the practice of law, and I've been practicing full steam. I was just in Oakland County Circuit Court this morning, as a matter of fact. So I'm located in Farmington Hills. I have business cards for you, but my contact information you'll find on page 3 of the Seller's Disclosure Statement bullet points. So what I want to do is I want to go through these bullet points with you. I try to keep it as not so technical and just kind of hone in on the important aspects of the Seller's Disclosure Act of 1993. And then I had a lawsuit in 2017 where I represented a homeowner who, after she took possession of the home, and several months later, actually, she took possession from when she closed, she took a shower and had her laundry going, and when she went downstairs to check her laundry, all this fecal matter and water was coming up out of the basement. So she had me sue the person who sold the company that sold her the house. That was the proverbial wholesaler, flipper. You know, he did make some cosmetic changes and whatnot. So you'll see in the next packet, and I want to give it to you now because I want you, we're going to kind of take a vote as to what happened with my lawsuit, and there's a 12-page opinion. Did I win or did I lose? And so we're going to get to that part 2. So part 1, let's take a look at the, I like this podium. Attorneys like podiums. So let's take a look at the Seller's Disclosure Act highlights. Now this is directed to, are there any brokers or salespersons in the audience? Okay, quite a few. All right, well this will help you out as well. You might find some surprises. And then of course I presume this gentleman owns 12 homes, so I believe you guys have a basic knowledge and have signed. How many of you signed a Seller's Disclosure Statement? Let me ask you that. Okay, we got quite a few. Okay, all right. So since 1993, all Michigan residential sales are subject to this act known as the Seller's Disclosure Act. All sellers of residential properties are defined as 4 or fewer dwelling units, must deliver to the prospective buyer prior to, I don't need these glasses, prior to execution of the sales agreement, the statutory form, the Seller's Disclosure Statement, which I will be giving you in your next packet. The Seller's Disclosure Act applies to sales, exchanges, land contracts, options, leases. I wasn't even aware of some of this myself. That include options or tenant improvements and co-op sales. It does not apply to a number of exempt transactions, including sales by a licensed builder of newly constructed residential property. So they're exempt from filling out the seller's disclosure statement. Some people think, well, I never lived there, so I don't have to fill it out. And that's not true, and we'll get into that a little later. You're obligated to fill it out. Now, if you don't know something, I highly recommend you check off unknown, which when we get into my case study, that's where the guy made a mistake. He wrote in there, never lived in the property, but then he went to the trouble of checking off all the boxes and checked off that the plumbing system was in good working order. Thus my lawsuit. Had he not done that, or just checked unknown, I never would have filed a lawsuit. But that was a misrepresentation. We're going to get into that. Pardon me?
I got a quick question, or maybe you're going to answer this.
Yeah, can you save the questions for the end? I want to bust through this.
You might answer it anyway.
I'm sure I'll cover it. Now, the form itself contains specific representations as to water in the basement, which is the story we're going to get into, my personal case study. Roof leaks, I had one of those. Septic tanks, drain fields, city water and sewer systems, well and pump, settling, flooding, drainage, sanitary and grade problems, infestation by wood-destroying insects, underground storage tanks, specified on-premises environmental hazards, and neighborhood environmental issues. Now, each disclosure must be made in good faith. The sole and exclusive buyer remedy under this Seller's Disclosure Act is to terminate the purchase agreement. That's your only remedy. If they lied on the seller's, let's not talk about the lying. If they said that the roof it leaks and needs well, you can get out. You don't want to. He doesn't want to spend, and you don't want to spend the money to repair the roof. You can get out of that purchase agreement because he disclosed he's got a leaky roof, and you don't want to buy a house with a leaky roof. So that's what it's meant by that. There are no post-closing Seller Disclosure Act remedies. Only lawsuits for fraud, deceit, and misrepresentation at common law, which you're going to see my lawsuit in a few minutes, and possibly a breach of contract when the purchase agreement includes warranties as to conditions that prove to be inaccurate. The form requires disclosure of any, quote, structural, mechanical, appliance system changes. So yes, the form, if something happens from the time you first fill out the form and you haven't closed yet, you are obligated to amend the seller's disclosure statement in these areas. Sellers are not liable for errors or omissions, quote, that are not within their personal knowledge, close quote. Remember that. And there is no duty to disclose information, quote, that could be obtained only through inspection or observation of inaccessible portions of real estate, or could be discovered only by a person with expertise in science or trade to be in the knowledge of the transferor. So generally, the buyer bears the risk of loss under, we're all familiar with the as-is clause in the contract, unless the seller fails to disclose concealed defects known to them. So you'll see my lawsuit is entitled Complaint for Failure to Disclose Latent Defects. Sellers have a duty to disclose to the buyer any concealed conditions known to them that involve an unreasonable danger. When evidence demonstrates a competent inspector, meaning a home inspector, should reasonably have expected to have discovered the defective conditions, the conditions are not considered concealed, and there can be no recovery for fraudulent concealment in connection with the sale of the real estate. And if it was clearly visible to a good, skilled home inspector. Buyers should be aware that they are subject to sanctions if their claims are determined to be frivolous, if they are devoid of legal merit. I came across a lawsuit, the buyer who brought the suit against the seller for failure to disclose, etc., in violation of the of common law, it was so frivolous that the court awarded the seller $40,000. I had $40,000, so, you know, tread lightly. I mean, any attorney taking on a case better be damn sure that they've got something going for them, which I did. So buyers are not obligated to conduct destructive home investigations. For example, sellers that have hidden cracked foundation walls with insulation panels, I had one of those, or covered cracked floors with carpeting, I had one of those. So how do you, they had a before picture on their listing, in the multiple listing picture, and it showed there was no carpeting, and so it showed there was like a blank floor, but it didn't like zero in on the fact, so they carpeted because there was a huge crack that went right across the, you know, the center of the floor. So we had some good proof that there was an intentional concealment when we laid down the carpeting. Fraud claims require a higher standard of proof than a mere preponderance of the evidence. All 6 of the required elements must be established. I'm not going to go into those 6 elements that are actually in the judge's opinion that you're going to get a copy of today in her case. A buyer's broker, there's a few in the room, is in privity of contract with the buyer and therefore can be liable for negligent misrepresentation. Contrary to the seller, who's not in privity, seller's broker is not in privity with the buyer. Since releases are enforceable, the seller will desire them and the buyer will ask that they be deleted. They are not enforceable if they are signed under duress or fraudulent or oppressive conduct was used to obtain the release. A seller's agent owes no fiduciary duty to potential purchasers. A seller's broker is not liable for negligent misrepresentation to a buyer because the required element of privity of contract is missing. There's no contract between the listing agent and the prospective purchaser. However, the seller's broker may be liable to a buyer if they acted openly with the seller in concealing information on the seller's disclosure statement. Sellers are liable for the statements of their agents, so you can be bound by something your agent did, some misrepresentation that your agent did. An agent assisting a buyer can be either a buyer's agent, a sub-agent of the seller, a dual agent, or a transaction coordinator. Buyer's agents obviously owe fiduciary duties to the buyers. A dual agent can obtain a contractual waiver as to fiduciary duties, which is understandable given the potential conflicts. And a lot of times the clients will say, well, you know, the home inspector didn't catch this, you know, let's sue the home inspector. And I tell them, hey, look at your home inspection agreement. You can bet that there's a provision in there that if they make a mistake, they're only responsible to pay you back what you paid them for a fee. And believe it or not, that is an enforceable limitation. Caveat emptor and as-is clauses in home inspections and the seller's disclosure statement protect sellers from most buyer claims. That's what gives them the protection. However, a false or misleading statement by the sellers or their agents or concealed defects can still provide recourse for an aggrieved buyer. And I had an aggrieved buyer. I probably didn't have to redact her name. It's a public record, but I redacted her name, so can we pass these out? Sure. I'll let you pass them out. So when you get your packet, you're going to see the complaint for failure to disclose latent defect. And as in all complaints, they're factual pleadings, so we give the factual background. I'll give you the cliff version of that in a minute here. I had a count for breach of contract, but the main thrust of the case was fraud, deceit, and misrepresentation due to the seller's disclosure statement. And behind the complaint, and I'll get back to that in a minute, is a blank seller's disclosure statement form that some of you already are familiar with and probably have in your office. And then behind that was an exhibit to the complaint. I mentioned this earlier. He wrote on here, owner never occupied, sold as is. But then when they had and checked off all the boxes, and in particular there's a box here for
When you highlight yellow, it doesn't come out when you Xerox it, but it's the city water system, city sewer system, and there's a plumbing system up the top there. So he checked off yes, instead of unknown. The pipes are like 50, 60 years old. They're made out of clay, not like today where they have PVC or whatever. And so getting back to the underlying facts, so this lady closed in February. The house had a swimming pool. She took possession. She went in and out of the house a few times, and but it wasn't until she actually had a full wash going and a shower at the same time that this problem in the basement came up, and they had to replace like 60 feet of line, of sewer line, at a cost of about $15,000. She did have a home inspection, and part of the rub of the case was the home inspector told her that the bathtub drainage was very slow. So she first hired, and Mr. Boxley's name in here, the license, not a licensed plumber, I was been a plumber for 35 years, but he uses somebody else's license, so I couldn't get him, the judge to rule that he was an expert witness, except for expert testimony. But we got the testimony in anyways. I mean, he had 35 years of experience. And so he cleaned out her drain. He came out the first time and cleaned out before she had the incident with coming up of the basement. So he did fix that drain. And then, so the incident in the basement was he ran a snake through, and sometimes they do cameras, probably aware that they do cameras, and he wasn't fancy, he was old school, so he did the snake thing, and determined that there were tree roots. So the tree roots destroyed, got in the way and blocked up all the, the debris, the fecal and sewage debris and all of that. So that's what caused it, is the tree roots. So when the seller took the stand, he said, "Hey, I checked this off because when I came in the house, I turned on the water and the sink was working in the water. I mean, in the sink, the water in the sink was working, the drain. I did the bathtub, I flushed the toilets." In his mind, the plumbing was working. So that's why he checked off that it was working. He did not go the extra mile at the time, thought he had to go the extra mile, and I'm thinking, like I'm advising clients, that maybe you do go, either check off unknown or go to the trouble of scoping, especially if it's in Southfield with these clay pipes that crack and tree roots grow in, to spend the money and run the cameras through there to see what goes on. So what happened with my case? Let's take a vote here. How many think I won the case? How many think I lost the case? You think I lost the case?
Yeah, you lost.
And everybody thinks I won the case. Well, I lost the case. So why did I lose the case? Well, I don't know if I want to take the time to read this whole opinion. I'm just going to give you, basically, I gave you that bullet point. First of all, she had a heads up that the drain, remember I said the home inspector said that the drainage was very slow on the bathtub? So she made an issue about other things, and he made a $4,000 concession. And he said had she mentioned, with her home inspection or whatever, or the sluggish, if she mentioned something to him, he might have done something about it, but she never mentioned it to him. So that was part of it. And then the other thing is that that clause that's saying that you're not responsible if something's scientific. So he's not obligated to run a camera through the pipes and all that. He did run, the toilet flush, the sink ran, and so it was something that was not easily discoverable, and clearly he didn't know about it. He was a straight, a lot of it's credibility. So he came across as a straight shooter type of guy and flipped a lot of houses, and his testimony was very, very credible, and the judge ruled that that was the type of defect that was not easily discoverable. And because it wasn't easily discoverable, he couldn't have misrepresented, and therefore, no cause of action, and my client was out not only the 15 grand that she paid for pipes, but had to pay me a few bucks, so. But she had her day in court. She was not, we're still friends, I still do business for her. It wasn't like, never wants to see me again. I did my best job that I could, and under the circumstances, and we lost. The one I won was where there's the concealment, is where there were those two pictures, with the before and after, where you put the carpeting down and hid the big crack in the foundation. That one I won. But they're not easy cases. I get calls, I do a lot of advertising on the internet, and I get maybe half a dozen calls a day, and one or two of them are always about disgruntled buyers that got stuck with having to pay something that they feel the seller must have known about. I had one out in Macomb County where there was mold in the walls and all of that, and that got to be a protracted matter. Ultimately, the guy was uncollectible anyways, and my client didn't want to spend any more money on attorney's fees. Litigation is very expensive. Most people, I quote them, you gotta have, I got one pending right now. Okay, so what is it? The guy bought a house with a swimming pool, $1 million house. And when he bought it, the pool was all covered up because it was like early spring. And the real comp and all that, they have these addendums that you can put in the purchase agreements for swimming pools, which really drill down on as is. You're taking it as is, but it wasn't on his purchase agreement, so he didn't have that. But when he went to open the pool in the summer, everything was broken. And we're talking $80,000 to fix this pool. And I think, the company that was that he was going to hire was the same company that would service the seller, and gave him and would be one of my witnesses that the seller had spent it all, was having them come out there once a week trying to fix something with the plumbing system. So, and I talked to their attorney. We just served him with the complaint, and I gave him some time to answer. But they're already indicating that they're gonna, give him some money back on the deal. I don't know if they're gonna give us $80,000, but they know that they did wrong. So that's, but they're tough cases. You're talking, if their damages are, most of the people that call, their damages are like around $5 grand or something like that. I say, hey, just go in small claims court and give it your best shot. If you hire me, I'm going to charge you $3 grand just to start the case in the district court. And if the damages are over $25,000, I got to charge you $5 grand. It's much more involved in the circuit court. So that discourages a lot of people. They don't want to spend the money. That's fine. I get it. I remember when I was 35 years old practicing law, and I'm thinking, I've never spent $1 on attorney's fees. I don't know how the hell I'm going to make a living getting people paying attorney's fees. But boy, did that change. At that time, I was 45, and then getting in the title business and having my own title agency. Yeah, I paid a lot of attorney's fees over time. So I've been in your shoes, so to speak. So now I can open it up to questions. Fire away.
Okay, I got a question. Back here.
I didn't cover it, huh?
What's that?
You said you thought I might cover it. I didn't cover it.
Yeah. So when the seller is filling out a seller's disclosure, let's say I'm selling a house I've never lived in. Would it have been all right to say on there, never lived in the property, and not fill out any of the boxes, just write it across the first page and the second page?
I wouldn't recommend that. I would just check off the box unknown.
Unknown and everything.
Yeah,
Okay.
if they didn't have that box, then yeah, that would be an issue. But the box is there, so just say unknown. And let them rely upon their home inspection. So, yeah, so a lot of brokers have you sign, the thing I question, like, have you noticed in a lot of purchase agreements they'll put like a 1-year statute of limitations in there? I'd like to see that tested. I'm told it can be enforceable, but I don't know. I'd like to test that one.
Well, the VATDAI became very prevalent when the foreclosure industry took over. So that was language that started getting put into the comments section during 2004, 5, 6.
What does that acronym stand for?
Buyer's agent to verify all info. And that's,
Buyer's agent.
yeah,
Okay.
yeah.
Okay, and how would, if you were a buyer's agent, how do you go about doing that?
Well, your due diligence is to go to the municipality and start, looking things up just to make sure
Right.
whatever's on file, whatever's
Oh,
on record.
I had a case where the broker could have been, I was gonna sue the broker, I haven't sued the broker in years, but this guy here was on a community well. So they said on the listing, he said it was city water, and he had a swimming pool. And it turns out it was on community well, which in a community well, when you do the home inspection, you can't tell, there's no meter like you can there's no device or whatever, because it's community well.
Why?
So it wasn't discoverable, but had she done what you're talking about and called to confirm that it's on city water, then they wouldn't have been exposed to litigation. But I had a good case there because the water, city water, well water in a swimming pool is no good. So he has to truck in water, and it was costing him like $2,000 every summer, additional costs that he didn't contemplate spending. And that was a good case. I'm sorry he never came back to go ahead with the lawsuit, but that would have been by people that buy tax forfeited properties from Wayne County auction. The title insurance, they get a quitclaim deed from the treasurer, and they don't get title insurance. And so we have to do a FOIA. When people call me about that, I say, well, have you done a FOIA request? No, what's that? And I explain, you go online, you get the FOIA request. Then I review the FOIA request. Then I do a full, chain of title search and determine whether or not. Now, the title company that I'm affiliated now, I should throw this out there. People think that you can't buy tax reverted property and get title insurance without acquiring title. It's not true. We can insure, provided that the person that bought the property didn't lease it back to the prior taxpayer and has owned the property from the auction for at least 2 years. And then, of course, provided that everyone that should have been served with the notice of the tax forfeiture were not necessarily in fact served. It's unlike civil litigation where you actually have to serve the people. You just, in the tax world, you just have to attempt to serve. Just, you send a certified letter and they don't pick it up or reject it, that's service. You drop it in the mail, that's service. So posting, you post it on the property, that's service. Unlike in civil litigation, you really, you have to get an order of substituted service, and you can't find the guy. I'm going through that right now with the guy. This poor couple came to me. They paid the man. He kept giving him a sob story. I mean, they're supposed to be paid in stages, right? They're building an addition on their house. So they paid him $47,000. He put up one wall. Now he's skipped town. We can't find him. They're out $47,000. So, in those kind of scenarios, I said, geez, if you'd come to me, we would put your money in escrow. We would have doled it out. You have to bring in sworn statements and waivers. Have inspections as to the percentage of completion. That's what banks do. Banks always have to have enough money to draw down in case somebody walks on the job to finish the job. You can never, if the job is only 25% complete and you've given them 70% of your money, what do you do if he walks and you gotta have somebody else finish the job? So that's how banks look at it too. So yeah, so quiet titles would be in the tax forfeiture area. How about a lot of people in Detroit? They die without a will and never probate the estate. So sometimes I can avoid quiet title by doing a probate. So you can get a probate order putting the estate in title. So each case stands on its own facts. But I've done a lot of quiet titles, and the amazing thing about a quiet title is even though there's no opposition, 9 times out of 10, but you got to make all this attempted services, and you got to wait 21 days for this and 21 days for that. It takes time. So if you're waiting to close a deal, you might wait, and you're waiting for the quiet title. It could take 6 months, 8 months. So what I recommend, if it's clear that you're going to get it, I recommend that the buyer take the exception. I call it an acceptable exception, but it's still incumbent upon the seller to go out and do the quiet title post-closing. So at least you get you close, the buyer gets title insurance, he's just got an exception in there, Joe Blow. So you got to get rid of Joe Blow with the quiet title action. Yeah,
So this has happened to more than one person in this room. I'll let the other person, if they want to say it, happened to them. So I'm a lead generator, and I find a good deal on a house, and I give it to my partner, who goes out, ties the house up wholesaler,
right.
and then we find a buyer, and it closes at a title company. Everything's great. We charge $10,000 assignment fee.
Right.
After the fact, it turns out that the person that sold the house didn't own the house. The
I
person
just did
that,
one for Mike Hagan. You know Mike?
Yeah, I know.
You got Mike?
The Russian guy, he's nice, yeah.
yeah,
Yeah, he's the one that got me involved with.
I know what house it was. I think I sold it.
On Perth.
I think I said.
Yeah.
so now,
Well, that's a clear title insurance claim.
Well,
I
yeah,
got this check like in 3 weeks.
that's wonderful, but now we're the wholesaler, and that same guy that we sold it to that has been frauded, now he wants his $10,000 back
Oh, the
that
10
we had
grand.
paid. So my question is, can I get title insurance for my 10 grand?
No,
No?
no.
Some title companies allow you to do that if you have it in the purchase agreement a certain way that, so if I get it under contract for 40,000 and I'm making 10, they could provide
They're pre-insured for 50.
yeah, you could get the title insurance, but you gotta do it a certain way, you gotta request it, and it costs a little more, not much, but I think it's worth it, you know, just to be on the safe side.
Right.
You know, for the buyer, you know, whoever buys it.
If you got a big fee, that's a.
And they don't necessarily pay you the, everybody thinks, well, I'm gonna get the cost, the full policy. If the property's actually worth, they pay you what your actual damages are. So if the property's only worth 45 and you've got $60,000 worth of insurance, and you lose the property, they're not gonna pay you $60,000. They're gonna pay you the value of the property. A lot of people don't know that.
Yeah, I've got a question along those lines. So I guess if you purchase a property for, let's say, $15,000, you get title insurance, and then you put $50,000 into it,
Right.
and then the house appreciates, so it's worth $100,000, and if something goes, you're only insured for the purchase price, right?
Right. So you have to bump that up.
So how do you bump it up? And
Yeah, just get an addendum. Insurance companies are happy to take your money. They'll give an addendum to the policy, increase the amount to include the improvements.
so it's up to the buyer
Yeah.
to select the amount?
Right, they're the ones that are gonna get hurt.
Is it the same rate as the first
Well, it's a
purchase price? I mean
No,
like,
the title insurance rates, it's a function of, it's so much like $5 a thousand for the first 50,000, and then $4.50 a thousand for the next 10,000. It's a whole,
so it's a declining scale as
Yeah.
the higher you go up?
Yeah, when you get up to $1 million, it drops down to like $1 a thousand.
So I can request that they insure it, say the purchase price is 50, and I plan to put in 50, I can insure it for, what's the limit?
Well, you
I mean-
should, you can insure it for fair market value.
All the way up to fair market value?
Fair market value.
At the time of complete rehab?
Yeah.
But even like, I guess, yeah, okay, so like 2 years later though, if it appreciates double.
Now, like on your deal, on the flip,
Yeah.
let's see how this works. So your flip, you're signing the purchase agreement. But the transfer tax, the actual deed, there really should be, let's see how this works. Isn't the deed, so if you're buying it for 40 and selling it for 50, the seller's gonna pay the transfer tax. What are you putting on the deed? Are you putting 50,000 in consideration on the deed, or?
What we're doing is just charging a fee for the assignment of the purchaser.
Yeah, but what's going on, the ultimate buyer is paying 50 grand, right?
Yes,
So is his title insurance policy gonna be for 50 grand?
Yeah,
Or for,
Well-
so the seller shouldn't have to pay the transfer tax on 50 grand, only on 40. And the buyer should be picking, you know what I'm saying? So
yeah,
there's
the
a.
buyer's gonna have to pay it's worth it for the buyer to pay extra.
Right, that's what I'm trying to say, which is kind of segues into what this gentleman is saying, so.
Yeah. Hey,
There's
so
because the seller's paying the transfer tax on that 15 grand, but anything over and above that, you would,
Okay,
I'm talking about transfer tax, so like.
yeah, so what we got
Right.
is
There's transfer
just,
tax and there's,
the buyer to
premium.
pay it and give him the difference of whatever it costs. Yeah.
Oh.
That makes sense.
So what happened to the days where you got A to B and then D goes in escrow, and then B to C, and then C gets a loan, and C's lender pays off the A to B?
Yeah,
Is
we
that
do
going
that
on?
once in a while. We do that once in a while, but
As long as C's lender does full disclosure and they're aware that the property just sold, 30 days before that for, $50,000 less, when they might balk and say, wait a minute, then why are we insuring this for X amount of dollars if it's not only worth? So that's the whole area of mortgage fraud that went on in the 2008 and 9. A lot of that A to B, B to C and thing worked out.
well, we're doing more double closing. If we don't assign it, at the same day, we'll do A to B and get transactional funding to close it.
Yeah, like a hard money lender for the short term.
Exactly.
For 10 minutes and then
Yeah,
and go and do the
yeah.
B to C.
Yeah, we had a case that blew up on me when I had my title company. And I don't mind saying it because I know he's a big celebrity. Does anybody know Lomas Brown?
Yeah.
All right, so Lomas Brown, I mean, he sold his house to John Holmes, not the movie star, for $5 million. And the house was only worth $3 million, and John Holmes' income, which was only like $3,000 a month, was filled out for $30,000 a month or whatever it was. And that case was a nightmare. And went all the way to the Michigan Supreme Court. The lender, Bank of America, and the title company were fighting the underwriter. And Lomas Brown, talk about celebrity status and how, in today's world and how these celebrities getting away with stuff. His name doesn't appear anywhere. It's not mentioned anywhere as a wrongdoer. He had to know his trainer can't afford to buy a $3 million house and that sold for $5 million. So it was overappraised. His earnings were screwed up. So there's a lot of ugly stuff that went on back in those days. But
He has stated income. It's back. He has stated income lenders.
yeah, back then the lenders, as long as you could, frost a mirror, they'd make you a loan, right?
Yeah.
Okay. Any other issues? Yeah.
I got a question regarding the foreclosure, about getting a redemption deed from the owner. Are you familiar?
You mean
with-
during their? Yeah, I've got one of those right now in Charlevoix County. It was $1 million home. During the redemption period, my guy bought at the sheriff's sale. It's a really convoluted deal. There was a first mortgage and a second mortgage. He didn't know there were two mortgages, so he went out there to bid on the first mortgage, and he was actually bidding on the second mortgage, which was already wiped out by the first mortgage. But then he got stuck for $120,001. He bid $1 more than the credit bid. And then 2 weeks later, he went and bought the first mortgage for $1 million. But then the redemption rights he was concerned about because he wanted to get going on this. So he did what you're talking about. I got a quitclaim deed and an assignment of, when I do it, I do two things. I get a quitclaim deed and an assignment of redemption rights. Two instruments, not just a quitclaim deed.
Okay.
So it's clear.
Yeah, I do what my title company requires. It's like a quitclaim deed, a redemption deed type of deal.
Yeah.
And there's like 5 other documents that they want them to sign that probably explains a lot of that, that what they're doing and things like that.
Right, that they've had legal advice and.
Yeah, but let's say an investor buys it at the auction for $1 over.
You're talking about tax auction?
Foreclosure auction.
You mean
Mortgage
sheriff's
auction.
sale on
Yeah.
a mortgage?
Yeah.
That's not an auction,
Yeah, well,
unless you're talking about an auction company.
no, I'm talking about the weekly auction. I go to it
Sheriff's sale.
every week.
He's going to the actual sheriff's
I
sale
go
in
to
the
the
county.
sheriff's sale.
Yeah, I never think of that in terms of an auction, I just sheriff's sale. Okay, go ahead.
Okay, yeah, well, they auction the properties off, but anyway, so an investor buys it for $1 over,
It's a bit, yeah,
and
credit
there's
bid.
a 6-month redemption period, and I'm already talking to the owner, and I offer him money to get the deed, okay?
Right, keys for, cash for keys.
Cash for keys type deal.
Yeah,
So the investor there's a designee fee that they do, an affidavit of purchaser, where this one investor is charging $3,500 to, if I had to go pay him off, you know, to do a payoff. He puts in there $3,500, which thank goodness they just changed some law where that fee only could be $250 now. They finally changed it. But, so my title companies are having, we can figure out the payoffs ourselves, but if I'm gonna sell it during the redemption period, I need something from my title company, because Wayne County won't provide the payoff letter. They used to, but they don't anymore.
Right, yeah, you have to rely on that affidavit. I got a case going right now, this is interesting. Pakistani fellow, so he has a first mortgage and a second mortgage with Chemical Bank. So the second mortgage was only like $45,000. The first mortgage was $950,000. So when he went to redeem on the second mortgage, he brought him a check for like $45,000 in interest and stuff. The affidavit that was filed by the lender was changed. They filed a second affidavit saying that they had paid off the first mortgage of $950,000 to protect their interest. So the payoff on his second mortgage for $45,000 was now like $1 million. So he was going to lose his house in 1 week, and I got an injunction from the court. I got it because the $950,000. Yes, the law allows you to do that, but what happened was the bank, when First Franklin Bank was bought by First Choice or whatever, it ends up in Chemical Bank. So it started out as a Franklin Bank loan. So he had a construction loan that converted to a permanent loan, so his interest rate dropped from like 12.75% down to like 4%. And he was making payments of like $2,000 a month on his interest-only loan. And then when Chemical Bank took over, they treated it like it was a construction loan. So they bumped his interest, so his payments went from like $2,000 a month to like $6,000 a month. And he couldn't afford to pay that. So I got it all, so now he's kind of living rent-free while I'm litigating it, because that affidavit increasing the payoff on the second mortgage, that $950 wasn't correct, because he didn't owe $950, he owed maybe $900 or something, because they were using the old interest rate instead of the reduced interest rate. So I've got some good arguments there. But and again, it's expensive litigation, but he's living there rent free because he's not paying any mortgage payments of $5,000 to $6,000 a month while this is going on. Maybe you have to catch up with it later, but maybe they'll refinance him at 2% rate or something to give him a deal. I don't know how that's going to shake out. Tune in later, I'll let you know what happens. Okay, anything else?
What's the latest on land contracts now? I keep hearing
What
that.
about land contracts?
How we can do them? You know, they changed the rules, that we can't do them, it's flip and flop in a few different ways, so I just don't know the most recent.
I did on a land contract today, and I don't know if you ever heard of the expression on which I use in this case that I just told you about the Pakistani fellow. The law abhors the clogging of the equity of redemption. So what happened in that case is he was waiting for them to foreclose on his first mortgage because he needed time to get his FICO score up and everything. So they kind of did an end run and didn't have to foreclose on the first mortgage because they bought it and tacked it onto his second mortgage. Okay, so what I did today is a guy selling on land contract, and he's worried about how long it's going to take before he can get possession back if the guy defaults on a land contract. So I did something that's probably clogging the equity of redemption. I did what's known as a quitclaim deed in lieu of forfeiture, and I did an assignment of the land contract purchaser's interest back to the seller, and that's being held in escrow. So if he defaults on his land contract, I'm authorized to do that and avoid, summary proceedings for. But and I told my client this. I said if he challenges it, a judge might set it aside. But if no one complains and you do that, and fine, you don't have to go through the summary disposition to summary proceedings to get rid of a land contract vendee that defaults. I don't know if that answers your question.
I hope you learned something today. I was surprised that 9/10 of the room thought that I won the case. I must have a nice presence, and I think kudos to them for thinking that, but the one guy got it right, I lost. Can't win them all.
So tell me a little bit, what was the class basically all about?
So my class was the highlights of the Seller's Disclosure Act of 1993, and then a case study where I represented a home buyer that sued the seller and ultimately lost.